My next guest will be one of the expert witnesses speaking to the Justice Committee at some point. Mary Ellen Turpel-Lafond is a former Saskatchewan judge. She is currently the director of the University of British Columbia's Indian Residential School History and Dialogue Centre, and she has been watching this whole SNC-Lavalin affair unfold, and she's with me from Victoria. First of all, thanks for your time today. It's good to have you join me to talk about where we are in this story and some of your thoughts about it. Let me start with what we saw today, and that is the former Attorney General, Jody Wilson-Raybould, standing up in the House of Commons during that vote and saying, I want the opportunity essentially to speak my truth. How significant of a development is that in all of this?
Well, I think it's a very significant development, but what I am encouraged by is it reflects her knowledge of the role that she played, which is the Attorney General's independent role. And so by abstaining, she has reinforced the fact that she will respect and stay within the constitutional role that she's had. So I think this was extremely astute on her part to do this. I'm sure it probably took some courage. I did observe the chamber by television to see that there was a bit of a reaction, but this was a constitutionally appropriate position to take. So I'm pleased that she's staying within the appropriate role where she needs to be.
Okay, and by that, in contrast, the suggestion by opposition parties that the Prime Minister had no business voting since he's the other party involved in this. What about him voting on this? Does that present a problem to you at all?
Well, the bigger problem to me, it was the client who's the Prime Minister, but also the current Attorney General should not have voted. So there was clearly not appropriate advice and reflection here. But nevertheless, I'm grateful in defense of the rule of law and our Constitution that the former Attorney General had the good sense to abstain and place on the record a very clear statement around her abstention. And this suggests to me that she is mindful of her role and that she takes it seriously. And this kind of responsibility continues with you even after you've performed that kind of public function.
Okay, let's stay with that. So what about the solicitor-client privilege issue? Because that keeps coming up, as you know, in this story. And the Prime Minister says he's waiting for advice from the current Attorney General about how to deal with whether or not it should be waived, how we proceed in this matter. But by the same token, the Prime Minister has been speaking out about this issue, as the new Attorney General, and we know in his statement of resignation, Mr. Butts put his thoughts on the record about what happened here, saying he'd done nothing wrong. So where does that leave us? Like, what are we supposed to think if they're speaking out about it, but she can't?
Well, I think this presents this very awkward situation. The former Attorney General has to stay in her appropriate lane. The solicitor-client privilege belongs to the client to waive. The client is not waiving the privilege. So it's a very odd situation where they've encouraged her to appear before a justice committee, which they've suggested will be an adequate process, but she doesn't have privilege waived. So what's the purpose of appearing if you can say nothing? And in terms of what she could say, a justice minister performs functions, the function of giving advice to government, being a public decision maker in terms of certain key roles. What is the scope within which she can speak? Well, she's probably going to have to err on the side of caution, but I find it to be a very dangerous situation where you're offering your former Attorney General to a committee to speak, but you're not allowing her to speak. So even though in some ways I feel like we've been through quite a process in the past week to 10 days, nevertheless, we're still stuck in the very same spot we've been in from day one, which is, I don't know if there's any basis to any of the allegations that have been advanced by the Globe and Mail, but they need to be independently reviewed with appropriate authority, and some factual determinations need to be made. And that can only happen if solicitor-client privilege is waived. And it doesn't have to be waived to a justice committee. It could be waived to another process, like an independent inquiry, or there's a whole range of opportunities how it could be waived. But the fact of the matter is, having the justice minister abstain, former justice minister abstain, and then saying, but she'll tell her story later, it's not going to be to the Justice Committee because they have to, between now and her appearance before the Justice Committee, waive it.
Right. So there's some question, obviously, about how constructive her appearance would be if she's still muted to some extent by solicitor-client privilege. You have said in the past that you thought the RCMP should be called in to look at this matter. Where are you now, given the developments of the last couple of days, and do you still feel that way? And what is the best process to get answers for Canadians here, if maybe it's not the Justice Committee?
Well, the position that I've taken has been a position based on the Constitution and the law of Canada, the rule of law. If, in the context of a Minister of Justice with some degree of responsibility for prosecutions, because there's an independent director of prosecutions, if a minister, attorney general, was pressured to intervene in a prosecution after a director of prosecutions made a decision, that raises the specter of inappropriate intervention in the criminal justice system that may give rise to a criminal matter. It raises a range of legal and political ethical issues. So it's about integrity. Mm-hmm. The criminal code has integrity offenses in it, like obstruction and influencing a public official. There's a whole range of issues that need to be explored. The key point that I've made, and I'll make again, is that independent fact-finding about what happened here is essential. Fresh air, with full light of that fresh air, has to be shed on what happened here. I hope, in defense of the rule of law and our Constitution, nothing happened. And we will all be assured of that, and we will move forward and say, we got very edgy here, we got very nervous, but we're all confident that this was appropriate. If something else happened, that needs to come out and we need to address it. So my concern from day one is this triggers a whole range of possible reactions. We should pick the most fulsome lane and then stay in that lane. And that lane, in my way of thinking, would be having an independent fact finder assess it with full cooperation. But I also know as a former judge that if you don't have people under oath, you can't compel people, and you can't make fulsome fact finding, then you are stuck in the shadows in an impartial understanding of what happened.
And is that argument, today we learned that the Prime Minister met with the Attorney General 2 weeks after her office, the Office of the Public Prosecutions Director, had decided to proceed with a criminal prosecution against SNC-Lavalin. Now, I don't expect you to necessarily weigh into that, but the Prime Minister wouldn't answer questions about who asked for that meeting or why or what was said at that meeting. Do we need to know the answers to those questions? And does that come back to the only way we're going to get them is with an independent outside inquiry?
Well, I think the issue from my viewpoint is that the law around this issue is not complex. It's actually fairly settled. It's well established in terms of a constitutional convention as well as in our statute and in our parliamentary tradition. So this isn't about what law applies. It's really about the facts. What are the facts here? And the nuances only become alive when we look at the actual facts. I don't know what the facts are. I'm not a fact finder. I'm not trying to be a fact finder. But what I'm saying is that fulsome review of facts is needed to determine within the established law, which is you don't influence prosecutions. We need to see where does it fall? And does it fall in perfectly acceptable behavior? Does it fall within issues of political integrity? Does it fall within issues of possible criminality? We don't know until it's been properly evaluated. At this point, we have allegations, apparently very credible allegations, because no one's threatened to sue them, for instance, by the Globe and Mail and others, that there was a timeline that suggests some kind of influence. We also have a puzzling fact, which at the time I was deeply puzzled by. Why was the Attorney General removed? This was one of our most competent attorneys general in a long time. And there was no question that her performance was, if not adequate, above average, if possibly even excellent. Why was she removed? So one of the very significant issues is, was her removal a consequence of her not collaborating or cooperating with a plan that was a more partisan or political plan? And that is really the issue that's hanging over this. And we'll never be able to answer that unless there's full waiver for her and she can speak to someone in a fulsome way. And others who are connected can also be appropriately examined and interviewed.
All right. Thank you so much for giving us your thoughts on this today, and Canadians can look forward to hearing from you at the Justice Committee when they do call you as a witness. Thanks for giving us some sense of where you are on this story with your comments today. Thank you so much, Mary Ellen Turpel-Lafond. We'll talk again.
Thank you.